Everyone, welcome back to New Post today, and let's continue with part 2 of August current affairs for the upcoming preliminary examination for UPSC in 2024. And let's get started with the issues. So the last time I stopped was at a Forest Conservation Amendment Bill, which amends the Forest Conservation Act of 1980, and also we looked into the Indian the Indian Forest Act of 1927 as well. So I would tell you to once again revisit those laws. So in my other post, I will be covering all the major bills that were introduced, especially during the monsoon session and also the winter session, and the features as well as the criticisms as well. So let's get started with an issue which was very much making news and related to the the Places of Worship Act 1991, which was passed by the then P.V. Narasimha Rao government to protect the religious places of worship. And this issue is with regard to the Gyan Vapi mosque issue and ASI. So recently the ASI was asked to file a report regarding the structure of the mosque that is actually being set to build on the existing Hindu temple, and it is in Varanasi. So the heart of this case is there was a plea that 5 Hindu women filed regarding their right to worship in the mosque premises, which was actually a Hindu temple, and this plea was not maintained, and later on the case went on to the High Court, Allahabad High Court, which gave ASI the right to survey the mosque. So at the heart of this issue especially is with regard to the Places of Worship Act 1991. Now this act was enacted to freeze the status of the religious places in India as they existed on August 15, 1947, and prohibits the conversion of any place of worship, and also maintains and ensures the maintenance of the religious character how it was as on August 15, 1947. However, there are certain other features and exceptions as well. So it prohibits the conversion. The act prohibits the conversion of a place of worship, whether in full or in part, from one religious denomination to another, and within the same denomination as well. It maintains it asks to maintain the religious character of the religious place of worship. So it ensures religious identity of a place of worship remains the same as it was on August 15, 1947, and the act does not apply to the ancient and historical monuments along with the archaeological sites remains covered by the Ancient Monuments and the Archaeological Sites Remains Act of 1958. It also excludes cases that have already been settled or resolved, and the disputes have been resolved by mutual agreement or by conversions that occurred before the act came into effect. The act does not extend to specific places of worship like the Ram Janmabhoomi Babri Masjid in Ayodhya, including any legal proceedings associated with it. And these are the issues with regard to the Public Places of Worship Act. Coming at number 2 is recently government imposed import duties on laptops and other electronic items. So let me tell you the data for you to remember is that China is a region from where we have the largest imports, like almost amounting to 9,400 million, and next comes Hong Kong, and in Singapore, which stands at 1442 million, Singapore at 1318 million, and Malaysia at 142 million. So the import duties were mostly put to reduce the imports and increase the local usage or the local manufacturing, because electronic items come under the PLI scheme of the government. At number 3 is the 72,000 crore project of the Great Nicobar project, and where a transshipment port is being built up, an international airport, a township, and also a gas and a solar based power plant is coming up. So what exactly is this Great Nicobar Island project? Now please look at the map and also have a good idea about the islands especially. Then the Great Nicobar Island project is a mega project that is being implemented at the southern end of Andaman and Nicobar Islands, and the project includes an international container transshipment terminal, a greenfield international airport, a township development program, and also a solar and a gas-based power plant over an extent of 16,000 hectares in the island. So the purpose is economic purposes, So according to the report of the Niti Aayog, the proposed port will allow Great Nicobar to participate in regional and global maritime economy by becoming a major cargo transshipment port. It was equidistant from Colombo to the southwest and Port Klang in Malaysia and Singapore to the southeast, and also positioned to the east-west international shipping corridor as well, through which a large part of the world's shipping trade passes. The second reason is the strategic reason, that is the proposal to develop Great Nicobar was first floated in 1970s, and its importance due to its importance for national security consolidation in the Indian Ocean region, that has been greatly underlined, and increasing Chinese assertion especially in the Indian Ocean region as well. There are certain criticisms, so the project will lead to a lot of loss of biodiversity, and also it is a part of the coastal regulation zones 1A and 1B. Galathea Bay, now which is being nesting, it is a nesting ground for the birds and many other species as well. Also turtle nesting sites, dolphins and other species will be harmed because of the dredging activity for the port. There will be an impact on the tree cover and the mangroves. So environments have said that there would be a lot of loss of tree cover and mangroves in the island as a result of the development of the project. A loss of tree cover will not only affect the flora and fauna in the island, but also will lead to increased runoff and sediments and will impact the coral reefs in the area. There is lack of adequate assessment. This is one of the other criticisms. So criticisms claim that only one season data has been taken and opposed to the requirement of taking data for 3 seasons for comprehensive impact assessment of the project and encroachment of the tribal place where we find the particularly vulnerable tribal groups in this region where they are highly concentrated, and it is going to affect them as well. Then the next most important issue is with regard to another bill, that is the Offshore Area Mineral and Regulation Amendment Bill. Now this bill seeks to amend the Offshore Area Mineral Act of 2002, and we know that India has a very large exclusive economic zone on the coast where India has a 7,516 kilometer coastline, and the proposed amendment will bring reforms by introducing auction as a method of allocating of operation rights in the offshore areas. Offshore areas means on the seashore or the continental shelf. I would say India has a very unique maritime position. India's exclusive economic zone covers almost 2 million square kilometers and holds many recoverable resources as well. So the GSI has delineated the resources of the following minerals in the offshore area. So almost 1,53 million tons, 1,53,000 million tons of lime mud within the exclusive economic zone of Gujarat and Maharashtra coast will be available. 945 million tons of construction grade sand off the Kerala coast. 79 million tons of heavy minerals placers in the inner shelf and the mid shelf of the Odisha, Andhra, Kerala, Tamil Nadu, Maharashtra. Phosphorite in eastern and western continental margins. Polymetallic ferromanganese modules and crusts in the Andaman and Nicobar Islands and Lakshadweep Sea as well. The next important issue is with regard to the press registration. So it's the fifth issue, the press registration and periodicals bill. Now this was introduced in the Rajya Sabha and it provides for registration. This act the bill provides for registration of newspapers, periodicals and also books. It provides for cataloguing of books as well. Now the bill provides for registration of periodicals, which includes publication any news or comments on the public news as well. Periodicals do not include books on science and academic journal. The bill allows the publisher of the periodical to obtain a registration certificate by filing an online application with the Press Registrar General and a specified local authority. The person who has been convicted of a terrorist act or an unlawful activity shall not be allowed to publish a periodical. Then it speaks about foreign periodicals. It says that the exact reproduction of a foreign periodical may be printed in India only after the prior approval of the central government. The manner of registration of such periodicals will be prescribed. It speaks about the Press Registrar General of India, and the act provides for the central government to appoint a press registrar who will maintain the registrar of newspapers. The bill provides for the Press Registrar General of India who will issue registration certificates for all the periodicals, and it deals with the registration of the printing press as well. So the act requires printing press to be declared before the district magistrate. The bill allows for information regarding the printing press to be submitted to the Press Registrar General through the online portal. And the sixth important issue is with regard to the Advocates Amendment Bill. Now this one deals with doubts, so you need to know the meaning of doubts, especially with regard to the preliminaries point of view. So the Advocates Amendment Bill 2023 was introduced, and it amends the Advocates Act of 1961. It repeals certain sections relating to doubts under the Legal Practitioners Act of 1879. So what exactly are doubts? Now the bill provides that every High Court, District Judge, Sessions Judge, District Magistrate, Revenue Officer may frame and publish the list of doubts. Doubt refers to a person who either proposes or procures employment of a legal practitioner in a legal business in return for a payment, and frequents places such as the prisons of the civil and the criminal courts, revenue offices, railway offices to procure such employment. The court or the judge may exclude from the premises of the court any person whose name has been included in the list of doubts. Now preparation, it deals with preparation of the list of doubts. So the authorities empowered to frame and publish the list of the doubts may order subordinate courts to hold an inquiry into the conduct of the persons who are alleged or suspected to be doubts. Now once such a person has been proven to be a doubt, his name may be included by the authority in the list of doubts. And this is nothing but regarding the legal practicing, especially. At number 7 is your FCRA permit. So recently an NGO called us, and previously many NGOs as well, have faced the scrapping of registration under the FCRA. This FCRA is very important for the functioning NGOs in the country, and those people who receive certain foreign gifts or hospitality, etc. So let's look into what is exactly FCRA. Now the Foreign Contribution Regulation Act is a law to regulate the acceptance and utilization of the foreign contribution or foreign hospitality by certain individuals or associations or companies, and to prohibit acceptance or utilization of the foreign contribution for foreign hospitality or for any and prohibits the use of foreign contribution or foreign hospitality for any activities that are detrimental to the national interest and for matters connected with that. So in 2020, Ministry of Home Affairs, who enforces this law on the NGOs, enforced this act, made certain changes to the act. So it included making it mandatory for the office bearers of the NGOs to provide their Aadhaar numbers, and it also gives the government the power to hold summary inquiry to prevent the organization from using the foreign funds. The changes were intended actually to increase transparency with regard to the working of the NGOs and also the usage of the foreign money from these NGOs as well. They also need to provide the accounts of the office bearers, the names of the office bearers, filing the income tax, and also they have to open a common account in the SBI branch, if I'm not mistaken, to avail the foreign funds that they receive from different areas. And at number 12 is the BRICS Summit. At number 8, is a BRICS Summit in South Africa. So the BRICS expansion happened during this, where the membership will take effect from January 24th, and the 15th annual BRICS Summit, which consists of Brazil, Russia, India, China and South Africa, was held in South Africa. And Argentina, Egypt, Ethiopia, Iran, Saudi Arabia and the UAE have been invited to join the bloc, and their membership has been accepted. This will take effect from January 1st, 2024, just few days from here to go. And at number 9 is your Article 370. So we know that Article 370 was included in a temporary and a transition provision under the Part 21 of the Constitution. So let's have a quick review of this. Recently, this article was scrapped in 2019 by the J&K Reorganization Act, and it removed Article 370 from the Constitution, which gave it a special status which could have, where Jammu and Kashmir had its own constitution, a flag and the autonomy with regard to internal administration. Now let me tell you that unlike the other states, the accession of Jammu and Kashmir to India was mainly based on 3 issues: defense, foreign affairs and communications in the beginning. All the princely states, when the reorganization was happening, they were invited to send their representatives to the Indian Constitution Assembly, which was framing the Constitution of India for that time, and they were also encouraged to set up their own constitution assemblies as well. However, many states did not do that, but some states did set up their own constitution assemblies, like Saurashtra. Most of the states could not, but few did, like Saurashtra, Travancore and Cochin, and even Mysore. Now, even though the States Department developed a model of constitution for these states, in May 1949, the rulers and the chief ministers of the state met in the States Department and agreed that separate constitution for the states are not required, and they were ready to follow the Constitution of India, and the states therefore did not elect the Constituent Assembly suggested, and only suggested a few amendments to the main Constitution of India document. However, in the case of Jammu and Kashmir, the state decided to form a separate Constituent Assembly for the state, and the representatives to the Indian Constituent Assembly requested they requested the Indian Constituent Assembly at that time that only those provisions of the Indian Constitution should be applied to the state which are corresponding to the original instrument of accession, and which the State Constituent Assembly would decide on other matters. Therefore, accordingly, the Article 370 to reflect this change, Article 370 was incorporated in the Constitution, which stipulated that it would apply to Jammu and Kashmir, and other changes to be made to the Constitution would be on the concurrence of the State Constituent Assembly. This was a temporary provision, and it was added in Part 21 of the Constitution, which deals with temporary, transitional and special provisions. However, the State Assembly dissolved itself without recommending either the abrogation or the amendment of Article 370, and thus the article became a permanent feature of the Indian Constitution. Now, the State Assembly could abrogate the Article 370 altogether, in which case all of the Indian Constitution would have applied to it. After the State Constituent Assembly of Jammu and Kashmir was convened, it recommended the provisions of the Indian Constitution that should apply to the state based on the 1954 presidential order, and based on its recommendation, a 1954 presidential order was issued. Now, since then, the State Constituent Assembly was dissolved itself without recommending the abrogation of Article 370, and therefore it went on to become a permanent feature. And as it includes now, either the State Constituent Assembly or the State Legislative Assembly can recommend on this, and when the State Assembly is under the President's rule, which happened in 2019, it is the Parliament which makes changes, which brings up bills for the State Legislative Assembly, and this is how the presidential order was enacted in 2019, and the J&K Reorganization Act scrapped the Article 370 of the Constitution. So legally also, this recently Supreme Court has upheld that 370 was a temporary provision, and the Parliament had the power to scrap the act. The basis is that either the Constituent Assembly of Jammu and Kashmir could have done it, or the State Legislative Assembly. But in 2019, let me tell you, because of a lot of conflict in the Jammu and Kashmir and its critical position at that time, the state was kept in the state government was suspended under President's rule. And when there is President's rule in a state, the Parliament has the power to make laws on the state list, and therefore it was the President at that time which brought out a presidential order to scrap Article 370, and this was recently upheld by the Supreme Court as well. So yes, so while speaking about these Article 370, the Supreme Court, when it was debating on the basis of the for and against about how the Parliament could have the right to actually scrap this Article 370, it raised an issue about the basic structure of the Constitution. Let's have a quick review of some of the major points, because recently even our Vice President Jagdeep Dhankar has been very vocal about how the basic structure of the Constitution is actually limiting the legislative power of the Parliament. And he was critical about that there should not be such a theory called as basic structure of the Constitution. So also basic structure was upheld in many of the recent cases. For example, basic structure was upheld when the Supreme Court itself scrapped the National Judicial Appointments Commission, and many other cases as well. And even in and recently 50 years of the bench, Kesavananda Bharati bench, which was formed in 1973, was celebrated. Let me tell you, it is the largest constitution bench ever to sit, consisting of 13 judges judges, and the Kesavananda Bharati case won on a majority of 7:6. So 50 years of this was celebrated. So the doctrine of the basic structure was propounded. It's not in the constitution. It was propounded by the Indian judiciary, especially to limit the amendment power of the parliament, because parliament is an institution created by the constitution, and the amendment power of the constitution is given to the parliament based on the constitution. The parliament cannot assume utmost power using its amendment power, and cannot amend any part of the Indian constitution, and especially those provisions which constitute the basic structure of the constitution. And this theory was propounded in 1973 by the Supreme Court under the then Kesavananda Bharati case, which put a limitation on the amendment power of the parliament, where at that time a pontiff of a mutt whose name was Kesavananda Bharati knocked the doors of the Supreme Court, challenging the government's power to take some of the land of the mutt, where he said that a right to property was one of the fundamental rights, and this could not be violated by the parliament. Now, the word basic structure is not mentioned in the constitution, and it was recognized for the first time in the Kesavananda Bharati case in 1973 itself. So what is the importance of this basic structure of the constitution? Number one, it promotes the ideals of the constitution. It maintains supremacy of the constitution. It maintains the separation of powers. It limits the amendment power of the parliament and also the lawmaking power as well, protects the fundamental rights, and makes the constitution a living or an organic document. The next most important issue is with regard to the cabinet secretary. Now, we know that the cabinet secretary is the topmost civil servant in the central government, and he is the ex officio head of the Civil Services Board, the cabinet secretariat, and also the Indian Administrative Service, and all the civil services of India work under the rules of business of the government of India. Now, the procedure, the precursor to the cabinet secretary was the then private secretary to the viceroy. So we had an executive council of the viceroy, where the viceroy used to have a secretariat. The head of the secretariat was the private secretary to the viceroy. At first, the role of the secretariat was merely just to take care of the paperwork with regard to the executive council of the viceroy, but once the individual departments under the council increased, the secretariat work also became very much complex, and the private secretary came to be known as secretary to the secretariat. At this point, at this post, it became very powerful over a period of time, and the secretariat's main role became to be the coordinating of work among the various departments. And in 1946, the secretariat became the cabinet secretariat, and the secretary became the cabinet secretary. Now, the cabinet secretary, as we know, is the topmost civil servant, and recently the appointments committee of the cabinet extended the term of Rajiv Gauba, who is now going to be the longest serving cabinet secretary in the country. And the extension was granted under the All India Service Rules of 1958 and also Rule 56 of the Fundamental Rules as well. The rules allows the government to give an extension to the service of the cabinet secretary in public interest, provided that the total term of the cabinet secretary who is granted such an extension does not exceed 4 years. And the next most important issues with regard to the contents of the data protection bill that was tabled in the parliament in the nearly 6 years after the Supreme Court upheld the right to privacy as a right under the constitution. Now, three separate versions of the bill. This is the recent version, and it was introduced by the Ministry of Electronics and Information Technology, and it was introduced as a finance bill. However, the minister said that it is not going to be treated as a money bill. Let me tell you, it is a speaker that has the right to certify the bill as a money bill. And the bill requires committees to protect the digital data taken from the individual. The companies are called as the data fiduciaries, and the individuals are called as the data principals. Now, the company needs to mention clearly to them what data are being collected and what are they being used for. They have to appoint and give contact information for a data protection officer, and also give users the right to delete or modify their personal data as well. And these requirements are very similar to the obligations of data protection laws in other countries, like the General Data Protection Regulation of the European Union. Now, the bill proposes a fine ranging from 50 crore to 250 crore for companies that fail to protect the user data or default on disclosure requirements as well. The bill lays the groundwork for establishment of a Data Protection Board of India. Appointments will be made by the Union government through notification, and it also strikes off 43 3A section of the Information Technology Act of 2000, which requires the companies to mishandle the data to compensate the users. The bill provides for a wide range of exceptions to the state and its instrumentalities. For instance, the personal data can be processed in the interest of sovereignty, integrity of India, and security of the state for fulfilling any obligation under any law. And while the law requires the firms to disclose the users of the identity of other firms to which their data would be entrusted for processing, they are exempted from disclosing sharing of such data in the case of lawful interception of data. And it empowers the government to access the people's private data, and also this is likely to create a surveillance state, which is the major criticism by the opposition parties. And the next one is the endangered Himalayan vulture bred in India for the very first time. So the first captive breeding of the endangered Himalayan vulture, called as Gibbs himalayensis, at the zoo in Assam. The category of this is nearly threatened in the IUCN Red List, and it is a common winter migrant to Indian plains and a resident of high altitude Himalayas. These birds breed in the Himalayan snow-clad mountains, but this is the very first time that a vulture breeding center established by the Bombay Natural History Society, one of the three in India, has bred a Himalayan Gibbs himalayensis, or a Himalayan vulture. Now there are 4 vulture conservation centers in India established by the BNHS, or the Bombay Natural History Society, that is Pinjore in Haryana, Bhopal in Madhya Pradesh, Rani in Assam, and your Raja Baktava in West Bengal. They are involved in conservation of the white-rumped vulture, slender-billed vulture, and the Indian vulture, and these 3 are critically endangered. And another most important issue is with regard to Arash in Iran, also called as Dora in Saudi and Kuwait. So what are these? These are offshore oil fields which are in conflict between Saudi, Iran and Kuwait. So they are called as Arash in Iran and Dora in Kuwait, and they have been a long source of contention between these 3 countries. Now located on the eastern maritime border of Kuwait, the Dora gas field was discovered in 1968. Iran calls the field Arash, which says that it extends into water, and even Iran and Kuwait claim it as well. And the next most important issue is with regard to a military agreement that was signed between Pakistan and USA. It is called as CISMOA, also called as the Communications Interoperability and Security Memorandum of Agreement. Now CISMOA is a foundation agreement that the US signs with its allies and countries with which it wants to maintain a very close diplomatic tie. It provides a legal cover for the sale of military equipment. The Communications Interoperability and the Security Memorandum of Agreement provides a legal cover to the US Department of Defense for selling of military equipment and hardware to other countries. The signing of the CISMOA indicates that US is ready to sell some military hardware to Pakistan. And the next most important issue is with regard to ECOWAS, or the East Community, or the Economic Community of West African States, and Niger. So Niger was in a coup recently, and the ECOWAS, or the Economic Community of the West African States, of which Niger is a member, intervened. So these West African countries come under a region called as the Sahel region. 15 West African countries established the Economic Community of West African States. They signed the ECOWAS Treaty on 28th of May 1975 in Lagos, Nigeria. The Treaty of Lagos was signed by 15 heads of the state. They are Benin, Burkina Faso, Cote d'Ivoire, Gambia, Ghana, Guinea-Bissau, Liberia, Mali, Mauritania, Niger, Nigeria, Sierra Leone, Senegal, Togo, with its stated mission to promote economic integration across the region. Now, the headquarters of the ECOWAS is at Abuja, Nigeria, and the only Arabic-speaking member, Mauritania, withdrew in 2008. And recently signed a new associate membership in August 2017. The aim of the community, or ECOWAS, is to promote cooperation and integration, leading to establishment of an economic union in West Africa and not the whole of Africa, trying to raise the living standards of the people and to maintain and foster economic stability among the member states. And the next most important issue with regard to, I would say the last most important issue today for the day, is the biological diversity bill facing opposition. For what reason? So the last time I told you that CBD, that is the Convention for Biological Diversity, came into being, and it is one of the important treaties, conventions that was adopted along the United Nations Framework Convention for Climate Change and the Agenda 21 during the Rio de Janeiro Earth Summit in 1992. And India is a party to this convention. On the basis of that, we have the Biological Diversity Act, which has three major goals, that is conserving biodiversity, promoting its sustainable use, and number 3 is equitable sharing of the benefits. However, the bill that is brought in, the Biodiversity Amendment Bill, violates all of these three. The amendments made to the bill are at odds with the Act and the intention of the Act. The Act aims to conserve biodiversity, promote its sustainable use, and equitable sharing of the benefits. The amendments proposed, however, are odd at these aims. The government spoke of ease of doing business and also promoting of Ayush, that is Ayurveda, Yoga, Naturopathy, Siddha, Unani and Homeopathy, as reasons why it is bringing these amendments. However, the bill exempts the codified traditional knowledge and the Ayush industry from sharing of the benefits with regard to these and with the local communities, and therefore denying the local community its rights and benefits from accessing biological resources. Also, the term codified traditional knowledge lacks a very clear definition and has a potential to be misused as well and also exploited as well. It decriminalizes offences and proposes monetary penalties instead, raising the concern over resource exploitation. And India, being a signatory to the United Nations Framework Convention for Climate Change and also the Convention for Biological Diversity, has the duty of protecting these ecological resources. However, the bill is in total conflict with the aims of the CBD. And this is for the part 2 of your August current affairs preliminary for your upcoming UPSC prelims examination. And I hope this was really helpful to you all. If you did, please do like, share and subscribe, and please do not forget to comment. And I shall see you in the next post with part 3 of August. And until then, it's very happy learning.